We're live. Okay. Good morning. It is April 29th. We're in Senate Judiciary. 4 went to the 5th long. Apologies about that, but I see that we have Lisa Pepe. Is that how I pronounce the last name? Thank you. So I know you've been waiting, so we can have the floor is yours, and happy to hear your thoughts on H105.
Great, thank you. I do want to preface this just by letting you all know our power at our office went out this morning. It's been smooth sailing the last couple of hours, but if for some reason that happens again, I'll just sign back in on my phone. But anyway, so good morning, everyone. My name is Lisa Pepe. I'm a Youth Restorative Services Coordinator at the Burlington Community Justice Center. Thank you for inviting me to speak today. I've been working with youth in the court diversion program since 2019, first in Franklin County and now here in Chittenden County. My role has included that of a case manager for the Youth Substance Awareness Safety Program, which I'll be referring to as YSASP throughout this testimony. You have already heard testimony making the case for alcohol violations for those under 16, but I'm here to speak specifically about cannabis. I feel that opening the eligibility age of cannabis referrals to the YSAS program would assist in streamlining the process for all youth, so we can take immediate steps in order to ensure that the youth is receiving the best care in a timely fashion. Currently, youth ages 16 through 20 who receive a possession of cannabis citation are referred to the YSAS program by the officer issuing the citation. Through this process, the youth will complete a substance use screening and meet with a YSASP case manager. We start by getting to know the youth a bit, asking about school, work, home, hobbies, etc. This sets a foundation for us to engage in deeper conversation about the incident, their screening results, and current substance use, along with risks and impacts of their choices. Through exploration of their frequency and amount of substance use, along with when and why they use, we are able to determine whether the youth will continue to follow up with a YSAS case manager, will be referred to a substance use counselor, or will require no further follow-up. Currently, if the youth is under 16, the process of getting to our office involves extra steps, including a charge that goes through the courts. Generally, the youth will be referred to court diversion, which would ultimately result in the youth going through a very similar process to what they would have received in the YSAS program. However, if they were sent through court diversion, the youth would now have a delinquent charge that would not be eligible for sealing until 2 years following completion of the program. If sent through court diversion, we are unable to mandate any form of counseling, including substance use counseling, whereas in the YSAS program, higher risk youth are referred to a substance use counselor for an assessment. The expectation is that the youth then follow the substance use counselor's recommendations, which may include counseling, and the citation remains open until that is complete. To provide an example of the timeline difference between court diversion and YSASP, I'd like to begin by reflecting on a case I received through court diversion for a youth under the age of 16 possessing cannabis. The incident took place in April 2024, and they were cited to appear in court in May 2024. Consistent with other counties, the youth was referred for a youth risk screening, or also known as a YAZI, with our agency, though in our county, the YAZI is not required before the state's attorney refers them to diversion. I then confirmed that the case did not require a youth risk screening because it was automatically being diverted due to the nature of the charge. The case was referred to court diversion in May 2024, and I was unable to schedule an intake with the family until June 2024. At this intake, we completed the same screening we used with the YSAS program. We discussed the youth's cannabis use, risks, impacts, and strategies for harm reduction. Throughout the next several months, I attempted to engage the family in the diversion program, but communication became more challenging the longer the process went on. The youth required more intervention with a substance use counselor, which I could have immediately referred them to during our initial meeting, had this been in the YSAS program. In the end, this case took 8 months from start to finish. By contrast, I received a referral to YSAS for a youth for possession of cannabis on March 19th, 2025 from an incident that occurred on March 14th, 2025. The youth completed a screening online and met with me on March 31st, 2025. The youth and I discussed the same things as I had discussed with the youth who was in court diversion, including frequency and reasons for use, risks, impacts, and next steps. The youth scored moderate risk, and together we devised some goals to decrease their cannabis use and find healthier alternatives. By our follow-up, I'm sorry?
No, there's just people yelling outside our committee room. Sorry.
It's okay. By our follow-up meeting on April 28th, their use had decreased greatly, and they were on the path to continuing decreasing their use. The youth completed the program in less than 2 months, and this was the YSAS program, compared to the 8 months it took for the youth in diversion to complete the program, and they made meaningful changes to their substance use. I feel that the most efficient and productive way for a youth under 16 years old to receive services around cannabis use would be for them to engage through the YSAS program. Rather than waiting months for services, we could intervene early to engage them in these important conversations, and we could do this without the fear of a delinquent charge. In addition to that, the current difference in processes for youth under 16 versus youth 16 and over has proven to be confusing for law enforcement, as we have received a multitude of YSAS citations for youth under the age of 16. This leads to an even lengthier process, as we then are required to reach out to the officer to let them know the youth is ineligible for the YSAS program due to their age. The officer then needs to cite the youth to court, or conversely, the citation is altogether dropped, resulting in the youth receiving no services at all. I believe that the best way to divert youth from a path of substance use is to educate them, hear them, and work with them, not to punish them with a charge or let them fall between the cracks. Our YSAS program educates youth on the dangers of cannabis use, along with exploring risks and impacts specific to their situation. I often have many youth say they learned something new about cannabis that they view as a reason to not use. This could be anything between the youth having big goals in life and learning cannabis may cause a lack of motivation, to youth learning about cannabinoid hyperemesis syndrome and determining that they're not interested in making themselves ill with cannabis. The ability to engage these youth at a young age in a swift manner increases the chances of youth receiving education and intervention to assist them in making informed decisions around cannabis use. Thank you again for your time.
Thank you for your testimony. Committee, any questions or comments? Not seeing anything, but thank you again for your testimony.
Thank you.
But we have like council to discuss the amendment.
Yes, thank you. Good morning, Ben Obergrowski from the Office of Legislative Counsel. Before the committee is draft 1.1 of a strike all amendment to H105. This amendment adds possession of cannabis to 7 VSA 656. You'll see in section 1. Do you want me to share my screen quickly to do this?
Sure, just in case there's people watching.
Sure. So bear with me one moment. So you'll see here, possession of cannabis. I've highlighted the changes from the prior version is added to the title, and then also as new subsection C. So it bumps down what was subsection C or subdivision C to D, and then the new operation impaired while operating provision is now E. The reason why I did that is from organizational. Subsection B is possession of alcoholic beverages. Subsection C is possession of cannabis. So kind of group that with possession offenses together. And what you'll see, this language is rolled in from 18 VSA section 4230 little b, which is essentially the equivalent provision to the alcohol statute that you see here, just in Title 18 for cannabis. So, and the way that statute is structured is exactly the same as civil violations for alcohol possession, where you have those potential penalties unless you enroll into YSAS. And so all that was done was essentially roll this language in from that statute, repeal the statute, and then leave all the provisions the same in 7 VSA 656 because it was the same in the other statute as well. So what that new language is someone who knowingly and unlawfully possess 1 ounce or less of cannabis, or 5 grams or less of hashish, or 2 mature cannabis plants or fewer, or 4 immature cannabis plants or fewer. So that's what you're possessing. That's what would be subject to a civil violation if you knowingly and unlawfully possess. So just as a reminder, knowingly is being practically certain that your actions will result in something, as compared to purposely, which is you have the conscious objective to do it. And so it's a little bit, basically you have to be aware of what your actions are. You don't necessarily have to intend to possess cannabis unlawfully. You just have to be practically certain that how you're acting may result in that.
I'm trying to wrap my head around how that would work in this instance. Does that mean you have to know that it's cannabis? Does that mean you have to know that you possess, like how?
So I think if you were like, for instance, if you didn't know it was actually cannabis, right? But let's say, you know, the classic example of oregano in a bag, right? If you knew that you were possessing a bag that thought maybe it was oregano, maybe it was cannabis, you are knowingly possessing something. That's sort of the knowing thing. You're aware of what you're doing. It's just not necessarily the conscious objective to purposefully possess cannabis unlawfully.
So it wouldn't
So it's
be,
a
I
little
picked up
bit-
my brother's backpack and didn't know there was cannabis in it.
It's a factual question that would have to be litigated. I mean, you knew that you picked up the backpack, right? So you'd have to know.
And you know your brother.
It is a fair assumption. So I guess my question here is, because we're including this in like the ability to refer
Mhm.
to this program, is if we're actually potentially leaving cases out by including this higher. Do you know what I'm trying to-
Yeah, so the way to think about it is that all of these, the alcohol related penalties are strict liability. So if you just have alcohol, doesn't matter what your intent is, mere possession of it creates basis for a civil violation. This is elevated. So it's not even criminalized as far as I've seen, just possession without that knowing element. So there's a gap, as you say, but maybe not in the result that you're indicating, in the sense that like there is no criminal penalty from a strict liability perspective of possessing cannabis. So you have to have that mental element of knowingly and unlawfully possession.
Okay,
That's it.
and because this is actually in the space that's creating the violation, it does not, because what I'm concerned about is if somebody gets in trouble for accidentally having cannabis, I want them also to be able to go and get the services and supports they might need. I don't want it to prohibit them because it was an accident. But my understanding on what you just said is that this is not going to do that.
It wouldn't, no. So if they accidentally, so let's use the brother's backpack example, right? If you get caught with your brother's backpack and it has cannabis in it, you are possessing it, you would have to go through the steps to do it. Even if it wasn't technically yours.
Trying to just, because I've seen this a lot, but if it's, so somebody can't negligently possess drugs, they have to meet that knowingly threshold. Anything below that, it's not possession. So that's, so I don't, you wouldn't be able to get a negligent or reckless possession of cannabis. There has to be the facts and the circumstances that show that somebody knowingly possessed it.
as long as everyone is, who could get in trouble currently, is able to move through the diversion system instead, I'm good.
Sorry, this is the last question. Or,
And I think that's the case because if you don't hit the knowingly standards, you're not in trouble.
correct.
And if you do,
And that's what I was trying to understand. I wanted to make sure we weren't putting a standard that created this sort of middle gray ground where people could get in trouble and not go to diversion. And I feel good that that is not happening, and so I'm okay. Thank you.
Yeah, and I'll go back down because there's another aspect of this that I think supports that concern as well. Like as in it doesn't make it happen. So that's how cannabis possession is worked into the bill. There's some technical corrections you'll see highlighted that just changed the cross reference since I bumped down the impaired operation portion, and you'll see at the bottom of the bill those two new repeals. One of 18 VSA 4230B that I mentioned before, and then new subsection C, which is a repeal of 4230J, which makes that delinquency. So, and if you recall, that was one of the issues that was remedied by this bill, is that if you were under 16, you'd have to go through family court and delinquency process for the alcohol violation. Well, the same concept is true for cannabis possession. So this is repealed, so there's no more delinquency associated with cannabis possession. It's all funneled through YSAS. And if you successfully complete YSAS, great. If not, then there are those civil violations that you can be held accountable for.
Cool.
Senator Lawrence.
Yes, thank you. I got one question. So the individuals carrying on a nickel or dime bag of oregano around, because everybody does that. Okay. Are they still eligible for this program? I we found that it is oregano. Anyways, moving on to my more serious question here. Why the white 12? Is that because the bill we just worked on as far as bumping up the age of those individuals being charged that have the house bill like this?
Right, yeah, so they bumped the alcohol violations down from 12 to 6 down from 16.
Right.
And so, you know, that it wasn't discussed in committee before about if you wanted a different policy approach to cannabis. So I just rolled in the possession in the current structure of the bill. So that could be a policy decision if you want it to be.
Not just wondering why. Well,
Yeah. Yeah, there is testimony about the evidence of 12-year-olds, at least as related to alcohol and alcohol use. I think that you had some testimony today on cannabis, but I don't know about that specific age range from 12 to 16.
Mr. Chair. So I think I asked about the middle of page 2 before, and that is for alcohol, it's 0.02 or more. So conceivably, somebody could have a 12-year-old, let's say, could have some alcohol in their system, but be below 0.02. But when it comes to cannabis, up above, it's unlawfully possessed 1 ounce or less, which I take to be any amount of cannabis. It lands you there. So I'm wondering, that seems like a disparity between alcohol and cannabis. And my question would be why the person's blood alcohol concentration is anything above 0.0.
Yeah, I think if memory serves from previous testimony, I think this embodies sort of a compromise of various stakeholders when this was passed the first time. So it was a policy decision that was made. So it's a policy decision that can change now if the committee feels appropriate. But there is another policy issue that I want to highlight for the committee as well.
Before we leave that one, was there any testimony that I don't know much about blood alcohol concentration? If somebody has not consumed alcohol, is there reading 0.0 or is there some trace level of alcohol and that's why they went with?
I'm not quite sure. I think that there are circumstances where that can occur, but I would not be the person to speak to that.
There are certain types of gums and chewing tobacco that if you chew and then you blow out the PVP a few minutes later, can show a pretty ridiculous breath test. So
And you'd be above 0.02?
I'm not sure off the top of my head. I mean, it depends how recent you had it in your mouth, but
Yeah.
Send it post.
There are certain instances that can happen, mouthwash is another instance where that would show a trace level amount. I think, so 0.02%, alcohol is about the equivalent of an average sized adult having one drink. So I think it would be pretty unlikely that a 12-year-old would have any substantial amount of alcohol and not club 0.02 or above.
So a policy consideration I want to highlight for the committee is on page 7, subsection B. The House added that a person shall not be cited for more than one violation of subsection A, and that's when it was the alcohol related offenses. Now you're introducing cannabis possession under one of the offenses of subsection A. So I want to highlight this for you all to consider whether this was still the policy you wanted to go forward with, since they're two different substances. So it's something that I thought might be.
So wouldn't that, so if that were in there and there's a teenager at a party, they have alcohol and they have cannabis, they would get the referral for one of them, but they would get a citation to go to family court for the other?
No. So if this bill as written passed right now, there would be no delinquency associated with cannabis possession. So the law enforcement officer would have to choose alcohol possession or cannabis possession to cite them for it.
And-
Why, what was I thinking? I'm sorry, didn't know.
Well, so previously, before the introduction of cannabis into the bill, you had to choose an alcohol related offense. Like, so sometimes if someone was caught imbibing, they could get charged for both possession and consumption. And so the House made the policy decision that, well, we're not going to cite you for both. Either the law enforcement officer has to choose. Because if you have to go through the process for kind of two different reasons or two different paths, maybe it was redundant. I think there was some testimony to that effect. But now that you're introducing cannabis and it's a different substance with potentially different rehabilitative courses, it could change things a little bit, but it was just something I want to highlight for the committee to think about.
It's an important item. The rehabilitative aspect is going to be my question. Do you happen to know if there are two different paths? Treatment for cannabis, treatment for alcohol?
Willem Farrell with the Attorney General's Office for Diversion and Pretrial Services. Now, when an individual is referred, someone who's older than 16 is referred to YSAS, sometimes they have both an alcohol and a cannabis violation, but the staff person works with the person in the same way. It's a sort of, they take a health focused approach. And so it's talking, as Lisa just described, about why they use, what are the effects. So there's not necessarily, if you're seeing a clinician, they might take a different approach. I don't know that, but I can say within our program, it's more the fact you're using a substance, and conversation is going to be tailored to that individual. That might be a little different, whether it's alcohol or cannabis, but the program itself, they don't go through the program twice. It's like, you've got 2 tickets, we're going to work with you as one person, and you succeed and both tickets are voided, or you fail and both tickets are issued.
So just a quick follow-up then, does it make sense from your perspective and the work that you do? Does it make sense to keep that sentence in there? Or
I would, primarily as it relates to alcohol violations, I think what is confusing, if you get a 0.02 ticket and a possession of alcohol, like those are 2 separate violations. Again, it's the fact is you had alcohol and you were driving. That's to me the most serious offense, and that would be the one I would think an officer would choose to issue the notice of violation. I think the way the bill is, this revision is drafted, would make it easier for law enforcement. There would just be one statute under which they are issuing these notices of violation.
So I was gonna advocate for keeping it, because it's redundancy as redundancy, sort of, regardless of if we're talking alcohol or cannabis. I also would imagine, and certainly speaking as a clinician, when an assessment is done, it's a wholesale assessment and an individualized treatment plan is built for every individual coming through. Regretfully, I wouldn't have the same exact treatment plan for every young person who used alcohol. Because to, Lila's point, there is an underlying assessment of why and what's going on and what are the life circumstances. So from a treatment standpoint, as a clinician, whether the citation was alcohol or cannabis is sort of irrelevant, because we're going to take a holistic look at the whole person, regardless of what they come in with.
Yeah, I'd go the opposite way. I wouldn't want this to be a part of that, because I'd want to see, as a clinician, what are the violations. I don't care that you can pick one of the alcohol ones, like was said before, but if there is alcohol and marijuana violations, I'd want to see both of those as a clinician, because you can take different paths with those. I don't know if a clinician would ever know if there was a possession for marijuana and in the same violation as the alcohol. So yes.
I just want to be clear. I actually am a clinician and I do this work. Like
Yeah, that's fine. That's great. I appreciate the work you do outside of the building. But what I'm saying is I would want to have documented that there was 2 violations made, one pertaining to alcohol and the other one pertaining to marijuana. Why wouldn't you? They're 2 totally separate things. I understand the alcohol part, where if it's possession or consuming totally, or driving totally, like, makes sense, because you're gonna take a path down that. But
Well, did you have your hand?
I did, thank you. If I may join in, I think our staff would appreciate knowing whether a youth had alcohol or cannabis or both. And so I think that information is important to know. And I think if there's a way to craft this bill such that there's only 1 violation per incident, I think is more. So I think the information about which substance is used is important, but I think if it's happens at the same time, then we would be looking at the individual regarding their health. And I think a single violation is adequate. So I'm sort of splitting the difference, I guess, between those 2 senators.
So is it that you're looking for a single violation, but making sure that there's information about whether it's alcohol or weed or both?
Correct.
So,
Or we go to violation.
or
the 0.02.
so then I don't know if this is a bizarre way of trying to write it, but is there a way to make one single violation a combination of possession of both alcohol and consumption? I'm sorry, consumption of alcohol and possession of cannabis?
I mean, I think you could write it in the sense that I think you could approach it from a couple of different ways. You could keep this current language, and then there's also language that that the court administrator, creates forms, basically embodying the will of this section. So you could say something to the effect of that someone shall not be cited, but for more than one, but if facts indicate that there's the presence of cannabis, alcohol, or both, that is indicated on the forms issued by the court administrator, something to that effect, where you're identifying the substances that are present or within the person's possession, but you're only citing them for a single violation. So it would provide the information to the powers that be, but the person would only be going through the process for the violation that the law enforcement officer cited the person for. Does that make sense?
It does.
I agree there, but except I don't want to overlook the importance of if we send an individual through the program and they say, oh, well, it's okay to use this substance, but not this one. Okay, so what I kind of wanna meld them together, say it's all right to bring both with you when they go. You're gonna put them through the program for one, but you need to discuss the center.
Yes.
You need to discuss all of the possessions here, because I don't want them to walk away and say, okay, well, I can use cannabis, but stay away from that alcohol, because they'll put you through that program for that. I just want to make sure, because we're talking about 12, 13, 14-year-olds here. So is that the message we would be sending them? Because obviously their brain isn't fully developed as of yet, right? 12, 13, 14 years old. So,
Well, what I hear the AG's office saying is that, given the information about the case, they would be addressing both
as long as
issues.
they do that, yeah.
And for the committee, I don't have a copy for everybody, but this is a notice of violation form
I was just thinking of that.
that shows
It's look the same.
exactly, so it has the different statutes listed right now, and then you'll see that the officer can highlight. And, so you have alcohol and cannabis or,
They do that if they're charging in those instances?
so it's for, they have the various violations. So right now, the ones under Title 18 that are separate from the Title 7 ones, and then also dispensing, which is a different set of laws, and then buprenorphine as well. So they have it all on one form for the officer to be able to select which ones are applicable to the situation.
Ben, thank you for bringing this. This is exactly what I was thinking of.
And I can
It's,
dig that up to send Will later.
Yeah.
So it's posted.
So I mean, if this, because there's the VCVC that gets written, and then this is also handed to the defendant. And so if we can change the language at the top, I think it's.
So potentially maybe the easiest solution is that
So what's a BCBC?
Vermont civil violation ticket.
Yeah, that's not a former police officer. I don't know your language.
So maybe the way to do it is to build out sort of the court administrator creation of forms language. So you're still only citing for a single violation here. Keep this language the same, and then maybe write some language saying that you need to indicate, all substances that the person was in possession of at the time, or something like that.
Quick question about that, and then we'll have to adjourn. If we are repealing 4230B,
Yes.
would that be problematic with trying to reword this, or should we?
I don't think so, because the two statutes, 656 and 4230B, are almost identical with the exception of the substances that they concern. So the vast majority of the Title 18 statute is already in, as far as the 656, as far as the process, it's just the basis of the violation itself that's in, right?
Any last quick question for Ben before we?
That makes sense to me as a platform.
All right, so let's revisit that, in the next couple of dates.
Okay.
That will, hopefully go themselves.
And I know we probably run out of time for H44, but I just wanted to quickly flag to the committee that I spoke with my colleague Damian Leonard, and House Transportation or Senate Transportation was working on, I think, S123 that had a little bit of an overlap. They also did those technical corrections to .08 and a couple other things, but David and I met. We don't think that there's a direct conflict, and in any event that there is, we'll deal with it in statutory revision, because it would be substantive conflicts that would have to change. So just want to let you all know that we dealt with it.
Sounds good.
Just before you take a vote on it.
Great. Thank you.